立法會主席。
President of the Legislative Council.
議員請返回座位。
Members, please return to your seats. Bills, first reading. Bankruptcy Amendment Bill 2015. Bill, second reading. Secretary for Financial Services and the Treasury. President, I move the second reading of the Bankruptcy Amendment Bill 2015. The bill makes a new arrangement under the Bankruptcy Ordinance Cap 6 of the Laws of Hong Kong to encourage bankrupts to fulfill their primary obligation in relation to the trustee in bankrupt's work in commencing the administration of the bankruptcy estate and will better protect the interests of creditors. The new arrangement will replace the existing arrangement under the Bankruptcy Ordinance. That is, if the bankrupt leaves Hong Kong under specified circumstances, there will be automatic suspension of the period for bankruptcy discharge. Currently, the ordinance provides that a bankrupt will automatically be discharged from bankruptcy upon the expiry of 4 years for first-time bankrupts or 5 years for repeat bankrupts. If a trustee in bankruptcy or TIB or a creditor objects to the automatic discharge of the bankrupt, the court may extend to the period to up to 8 years. And also to avoid the leaving of Hong Kong in order to have automatic discharge by bankrupts so that they do not have to discharge their obligations, and so there will be prejudice caused to the creditors. Then the bill specifies that without notifying the TIB of her itinerary or contact means, or if he fails to return to Hong Kong as required by the TIB, the automatic suspension will be stopped until the bankrupt has returned to Hong Kong and notified the TIB of his or her return. This arrangement is known as the abscondee regime. The automatic suspension or automatic discharge and the abscondee regime were set up in 1998 according to the recommendations of the LRC. The CFA pointed out in a recent judgment that the restraint imposed by the abscondee regime on the bankrupt's right to travel went beyond what was necessary for the protection of the rights of creditors. Also, the sanction applied irrespective of whether it had occasioned any prejudice to bankruptcy administration, and also there was no discretion vested in the court in this matter. Because of this, the administration reviewed the abscondee regime and in May 2014 consulted the FAP of Legislative Council of the review results. We have considered the views of the panel and stakeholders, and now we like to propose the new arrangement as carried in the bill. Under the new arrangement, if a bankrupt fails to complete the initial interview with the TIB, causing prejudice to the administration of the bankruptcy estate by the TIB can apply to the court for a non-commencement order. Specifically, a bankrupt has failed to complete the initial review if he or she has 1. Failed to attend the initial interview with the TIB, or 2. Attended the initial interview but failed to provide at that interview all the information concerning his or her affairs, dealings, and property as reasonably required by the TIB. The main point of the new arrangement is to encourage the bankrupt to complete the initial interview with the TIB and to supply the necessary information in order to help the TIB kickstart the administration of the bankrupt's estate. The court can exercise the discretion in order to decide when to start counting the discharge period. And that is until the clauses in the judgment made by the court are complied with. If the court will make the order, then the automatic discharge period of the bankrupt would be seen as have never commenced. In other words, the period for this bankrupt to have automatic discharge will be extended. The bill will give the court discretion to consider all the relevant factors of individual cases and also representation of the bankrupt before making a judgment. In the non-commencement order, the court can stipulate certain clauses, and when they are complied with by the bankrupt, the TIB will have to give notice to the court within 14 days, and the automatic discharge period will be counted starting from the day there is compliance of the clauses. Compared to the existing abscondee regime, there will be two improvements under the new arrangement. Number one, our consideration is based mainly on the conduct of the bankrupt and whether it will cause prejudice to the administration of the estate and not whether the bankrupt is in Hong Kong. According to the experience of the official receiver's office, the initial interview is most important to the administration of the bankrupt's estate by the TIB. If the initial interview is not completed, the TIB will not have enough information and documentation from the start in order to discharge its duties. And probably there will be prejudice caused to the administration of the bankrupt's estate, even if the bankrupt does not leave Hong Kong. However, if they do not complete the initial interview, there will still be prejudice caused to the administration of the bankrupt's estate. The new arrangement can take care of this situation. On the other hand, the new arrangement also gives the court discretion to decide whether to make a non-commencement order. It also replaces the abscondee regime where there is automatic suspension of the relevant period for bankruptcy discharge. Therefore, the CFA and its constitutionality concerns will be resolved by the bill. If the bill is passed by LegCo, we propose to have it implemented starting on the 1st of November 2016. And it will only apply to debtors who are declared bankrupt on or after the implementation date. President, with these remarks, I urge members to support the proposals to maintain the integrity of Hong Kong's bankruptcy system. I now propose the question to you, and that is that the Bankruptcy Amendment Bill 2015 be read the second time. In accordance with the rules of procedure, the debate is now adjourned and the bill is referred to the House Committee.
Council is now in committee to continue to consider the schedule to the